Welcome to the No Unfinished Business podcast. There are 1,000 different ways your clients can leave unfinished business, but no single advisor can address every issue. In every episode, we'll answer the important questions to help professional advisors focused on individual clients. Attorneys, CPAs, and financial advisors identify and eliminate those planning blind spots so you can speak competently and confidently to your clients and help them leave no unfinished business. Adri Graves, thanks so much for joining us today.
Well, thank you for having me, John.
So, Adri, you own your own law firm, and what y'all do, among other things, fights involving guardianship, sometimes just regular guardianships. What I've learned over the years, what seems kind of obvious on what a guardianship is not so obvious to those who don't deal with it. So, Adri, as we get started, what is guardianship? Where do we even begin on this?
So, a guardianship is necessary when someone is unable to provide food, clothing, and shelter for themselves, maybe unable to make medical decisions for themselves, and unable to make financial decisions for themselves. That is the definition of incapacity for the courts.
So how do we know when is there just a, you are this many meals past or you have missed this many showers? How do we know when you've actually tipped over and you need a guardianship?
Good question. The definition of incapacity is vast, very broad, and it's a sliding scale. It goes from a partial incapacity, which means that you may not be able to do some of the tasks necessary to support your daily life. But the other end of the scale is total incapacity, where you are completely without capacity to make financial or medical decisions for yourself. And so there's a physician's certificate of medical examination that the courts here in Texas have adopted, where you have to have a physician or a psychiatrist complete this form letter. And it's about 3 pages long. And it's got a laundry list of tasks that a person is able to do or not able to do. And so it's literal check boxes that a doctor fills out. And it has things from, are you able to manage a bank account? And if so, how much should that bank account be? To medical decisions, to are you able to enter into contracts on your behalf? Are you able to marry? There's just a number of laundry list of items that a doctor will complete. And that doctor's certificate of medical examination is what gets submitted to the court. The court cannot do anything. The court can't create a guardianship. The court can't find anyone incapacitated unless and until there's actual medical evidence of incapacity.
Right. So you've got to actually get somebody backed up to do this. And in terms of doctors, I know you said doctor certificate and psychiatrist, but is this any old doctor can fill this out, or do you need specific doctors to do this?
I mean, typically, if a client comes to me where we are trying to get guardianship over one of their loved ones, I always suggest that they go see the person's treating physician, their primary care physician, someone that has a long-standing history with them, with the patient, or what we in the guardianship context call the proposed ward. You're a proposed ward until you become a ward where a guardianship is created. So I would always like to see a doctor that has some kind of relationship with a proposed ward, whether that's a primary care. Also, neurologists are a great option as well because they deal with levels of capacity day in and day out.
Right. So your podiatrist probably not the first choice on this.
No.
But I've had these feet issues for years. We've got the check boxes, 3 pages worth of check boxes of can you get married? How big of a bank account can you have? You mentioned partial and total incapacity. So for total incapacity, is that they've ticked every box the wrong way, or is it 75% of the boxes, some of the boxes? Where are we on that scale?
Total incapacity is you have checked all the boxes on the laundry list. A partial incapacity would be you've checked maybe one or all the boxes except one. So that's how big of a sliding scale this is.
Okay. And just from your own thoughts, how many people are actually totally incapacitated versus the partial, just in maybe even in what you see in your practice?
I think the majority of people are partially incapacitated. There's findings of partial incapacity because they may retain the right to manage a very small bank account that has less than $100 in it, just to give them some levels of autonomy. The courts are always trying to avoid a guardianship. So they want to, when you file an application for guardianship and when you actually have the hearing, you have to put on proof, actual evidence that there's no alternatives to guardianship. There's no lesser restrictive alternatives for the proposed ward. And the court is always looking to make sure that the ward can preserve as many rights as possible. There may be someone who can't manage a financial account and can't give the authority to consent to medical care, but they still have some faculties about themselves and they really enjoy voting. So in those cases, we let them save their or retain their right to vote.
Right. And the alternatives, first things first, thinking, well, what I hear frequently, my child's about to turn 18. They are not ready to be on their own. I need a guardianship. Is that something that we can do anything about?
Well, if the child has some level of incapacity or special needs, for example, absolutely. But you're going to have to get a doctor to make that decision. The doctor is going to need to assess the child or the young adult that's just turned 18 and decide what levels of capacity that particular individual has. If a parent wants to go out and get a guardianship over an 18-year-old just because they're making poor choices, that's not going to work. And there's also, you raise a good point because many people come to me with young adults or children that are adults now, but not quite fully formed, and their part of their brain that exercises judgment is not quite mature yet. And maybe they have substance abuse issues or mental health issues. The substance abuse issues are really tricky because a guardianship can't be based on just one offs here and there. It has to be consistent for a certain period of time. And you have to show that this is something that will actually affect that individual's right or ability to provide food, clothing, and shelter for themselves, make medical and or financial decisions.
Yeah. So it's not just they're 18 and they're going to blow all the money if we give them anything, or I want to make sure that I still get to see their grades when they go off to college.
No, there are alternatives that a parent can do, which I would highly recommend any parent that has a child that is about to turn 18 and about to embark on being an independent individual. If your child is consenting and they understand what they're signing, get that child before they leave for college, once they turn 18, to sign medical and statutory durable powers of attorney, HIPAA releases. I've had some situations before where if those had been in place, the doctors could have shared medical information with the parents and we could have avoided guardianships or temporary guardianships, which are for emergent situations.
Yeah, and that's the thing where parents do come in, they want their kids to still be able to be taken care of, but once they turn 18, those kids are no different than asking for medical information about the stranger walking down the street.
Correct. And most doctors are pretty stringent on HIPAA violations. I will say for parents of a child that truly has special needs, if they've started the guardianship process or they're just trying to get to the guardianship process and their child is at or nearing age 18 and it's a primary care physician or a pediatrician that has a very long-standing relationship with that particular patient, they typically are a little bit more lenient and will work with the parents. But there comes a point in time where those doctors, that their policies just don't allow them to share information with the parent. And so those are the situations where if you have a child that has special needs, I suggest starting the guardianship process sooner rather than later, before that child turns 18, so that there is no lapse in time for you as the parent to be able to continue to help your child or may actually make those decisions for the child if the situation warrants it.
Yeah, we'll come back and we'll talk a little bit more about process in a minute. I want to, before we get away from that, the what is those alternatives and the lesser restrictive alternatives? And I know powers of attorney are one that we use all the time for our clients. Just here, this will get you through a pinch, maybe even a few months of incapacity because you're in the hospital. But what are some other things that the court would say, well, you don't need a guardianship, you've got this instead?
Powers of attorney are always great alternatives to guardianship. Sometimes a HIPAA release will do it if there's someone that maybe, for example, they're have a mental health issue and this is something that can be treated where the child can or the adult regulated and back on track. Sometimes a HIPAA release will work. Other alternatives are the least restrictive guardianship absolutely possible. There is a statute that's supported decision making ability. I have to be very honest, I have never used that before because while it's great and it affords an individual that may have some level of incapacity with the ability to make decisions. It's not binding. They can revoke it at any time. They can change who their supported decision maker is. And so, in many situations, it's not something that I recommend for people because it's not a permanent solution.
Got it. And is there any difference between alternatives or lesser restrictive means, or is that just all one big concept?
Alternatives to guardianship would be something like a power of attorney, where there is an agent that has the ability to make medical or financial decisions on someone's behalf. The lesser restrictive alternatives are things like the supported decision making, or there's a pooled trust in Texas where you can deposit the individual's funds and have those funds managed by a state agency so that they retain a little bit of autonomy to manage their funds, but it's managed under a state agency.
Got it. Okay, so let's back up to the start. You know, client is in front of one of our listeners. It's probably not the client themselves. It's probably a family, either elderly family member, mom, dad, maybe a grandparent, maybe it's a younger child. What are some of the warning signs that aren't specific diagnoses? Is there anything that as an advisor you hear them talking about, oh, mom was doing this or that, or, anything to start thinking as these are warning signs?
I think you're always looking for changes in the person, maybe where they're not able to, they're having some memory impairment issues, or they're making some decisions that are very contrary to decisions that they had made previously in the past. Also, some warning signs that we see are individuals popping up in this person's life that maybe have not been a constant fixture before, whether that's a family member or a third party. Other warning signs would be drastic or even small changes in some type of estate planning, whether it's a long-standing estate plan or something fairly recently. Also, warning signs are when you've got children of an individual that are, we've got powers of attorney, and then we've got a revocation of a power of attorney, and then a new power of attorney. So if you're a financial professional or an advisor and you are being fronted with these competing powers of attorney, that's a huge warning sign for you right there.
Got it. So from there, you'd mentioned we need a physician certificate. We also need to know to go ask a physician for this. What does the process of a guardianship look like?
Okay. So it starts with a guardianship application. And with that guardianship application, the court is not going to move forward without having the physician's certificate of medical examination. There are some situations where you're simply unable to get the proposed ward to a doctor. Maybe there is, a family member that has squirreled the proposed ward away and you don't have access to them, for example. And so there is a mechanism in the courts to do a motion for independent medical examination. And what that does is the court says there's some evidence that a guardianship may be warranted, enough that it allows the court to say, hey, we're going to invade the rights of this proposed ward. It's a burden that you're going to have to meet as the applicant to meet the test for that, because courts are going to look at it, and the attorney ad litem, which we'll get to in a minute, but the attorney ad litem, they are probably going to push back on that because maybe the proposed ward doesn't want to be assessed. But there is a way to get a physician certificate if there is conflict among the family and you can't get that doctor's letter. But you file the application, you have to have your medical evidence to support that application, and then the court will appoint an attorney ad litem. The attorney ad litem is going to represent the legal interest of the proposed ward. What that means is whatever the proposed ward says, they're the mouthpiece. They could come up with the craziest person that they would like to serve as guardian. The attorney ad litem is duty bound to convey that to the court. Attorney ad litems are appointed in every single guardianship because what you're attempting to do is take away the proposed ward's rights. And so courts are, that's a big deal, and they want an ad litem to be representing the legal interests. Some situations warrant the court's appointment of a guardian ad litem. The distinction there is the guardian ad litem is going to be there to represent the best interest of the proposed ward, not the legal interest. So what they do is they come in, they review medical records, bank records, talk to family members, talk to third parties, do interviews, and they provide a report to the court to let them know what's going to be in the proposed ward's best interest. If it's uncontested, you're not going to have a guardian ad litem in most cases. You'll have the attorney ad litem. If there is not a contest and the proposed ward is consenting, then you have a hearing and the court appoints a guardian. If there is a contest, that contest could come from the proposed ward, where the proposed ward says, I'm not okay with a guardian. In that case, the attorney ad litem has to contest the guardianship. Or a contest can also come from a third party that's also attempting to be guardian or asking the court, hey, the proposed ward is just fine. We don't need the appointment of a guardian. So once you're in a contested situation, you are in a totally different pathway. You're not on the court's uncontested docket. You're in contested litigation, has a trial date and a docket control order and lots of deadlines, and you're off to the litigation races.
And that, just to close out on the guardian ad litem versus the attorney ad litem. Attorney ad litem has to be an attorney. Is the guardian ad litem always an attorney?
Yes, and these are attorneys that, not only are licensed attorneys, but they have to have completed a guardian ad litem certification. You have to have a certain type of special certification in order for the court to appoint you in those capacities. And actually, to file an application for guardianship, you have to have this guardian ad litem certification as well.
Got it. So you talked about things going wrong with contested litigation. If we think the proposed ward is going to fight this or not be amenable to the guardianship, what are things to think about? What are the ways to minimize that, hopefully get it resolved faster?
Well, there's a lot of different options. One is, an early mediation session, because the attorney ad litem is going to be there serving as counsel for the proposed ward. So that person is going to have an advocate, someone to advocate on their behalf and hopefully structure a deal in mediation that protects the proposed ward, but also allows the proposed ward to retain as many rights as possible. And so mediation is always an option, just trying to work on figuring out a solution, which sometimes is going to say no family members will serve as guardian. Sometimes they'll agree to appoint, it will be a court appointed guardian. And again, that's going to be a licensed attorney that practices in the probate courts, that the probate courts will appoint to serve as the independent guardian for this person. There's also something else that kind of takes the family conflict out of these contested situations, and that's to take the proposed ward's estate, so their financial assets, real property assets, everything that they own, and create what's called a Section 1301 management trust. And what that is a court-created trust with a court-appointed fiduciary, typically a trust company, and they are able to effectively scoop up all the proposed ward's assets and manage it. And this is what they do all day, every day. They have staffed their trust company such that they're able to pay the bills, provide housing or placement for the proposed ward. They have resources to care managers. They have a lot more resources than the average Joe off the street. And so those are also great alternatives, because not only does it take the conflict out of the family, it places the funds with a corporate fiduciary that is duty bound to be prudent with those funds and invest them and make them grow, but to also provide for the proposed ward. And their fees are going to be tremendously less than going through and having the court appoint a guardian of the estate for an individual, because that's going to require an accounting each year. That guardian is going to have to be bonded in an amount equal to what the ward's estate and income are. So the corporate fiduciary and 1301 management trust is a great alternative.
Excellent. Well, Adri, that's probably a good enough place for us to end right now. For anybody looking to get your help on a guardianship, where can our listeners find you?
They can find me at graveslawprobate.com and Graves Law.
Great. Adri, thanks so much for stopping by.
Thank you.
Thanks so much for listening. You can find more episodes, videos, and links to more helpful content at nounfinishedbusiness.com. If you have any questions, feedback, or ideas for topics, please reach out via social media or email John at john@stromeyerlaw.com. And of course, if you or your clients need help from John with an estate planning, probate, trust, or cross-border tax issue, you can book time directly with John at askjohnaquestion.com.